Here's the scenario. You're the President of the United States, and there's a longtime ally elsewhere in the world who has been somewhat arguably tyrannical in administering his government. But there's a revolution because of this tyranny, and the new government is radical. It's not entirely clear that it's friendly. It starts exporting its philosophy, and you're worried that they're infiltrating the United States. So what do? Well, the president that I'm about to talk about decided to push through a legislative agenda to protect the country that would include two principal components. One, a statute that allowed him to identify dangerous aliens and deport them from the country on his own authority. And if they came back, having been deported, he was empowered to send them to prison for a length of time he would determine based on security of the United States. The second statute would allow federal prosecutors to prosecute anyone who had badmouthed the government, said disparaging things about the president, said disparaging things about the country or the Congress or the Constitution. If they printed these, uttered them, wrote them, they were subject to federal criminal prosecution and could and would be sent to jail. Now, this isn't a modern scenario. The president I'm talking about is President John Adams, our second president, and the tyrant who's overthrown is the King of France, our ally during the American Revolution. And the French revolutionary government decides to export its philosophy of liberty, equality, fraternity across the European continent. There are sympathizers, active supporters of this view within the United States, most all of them members of the opposition political party, the Jeffersonian Democratic Republican Party. And John Adams and the Federalists in 1798 decide they better protect themselves and, in their view, the country by pushing through a series of 4 statutes that collect into 2 titles, the Alien Act and the Sedition Act. The Alien Act, I'll say a word about. And then I'm going to talk mostly about the Sedition Act. The Alien Act, in its material provision, says essentially what I've already alluded to, that the president is empowered by the Congress to identify dangerous aliens. Now mind, these are folks here legally, and deport them if he believes them to be a threat to the security of the United States. They can request a license to stay, which he's empowered to grant, but it's his discretion. If he deports them and they come back, then he can send them to jail for a length of time to be determined by him in his discretion. And the basis for that decision is to be the security interests of the United States. The Alien Act aroused a fair amount of opposition, but as I say, it's not going to be the focus of this talk because I want to tell you about the act that's generated the greater amount of scholarship, which is the Sedition Act. And the Sedition Act said, essentially, what I've already stated, which is that if a person has written or uttered or printed something that's disparaging of the interests of the United States, I'll read you the exact language. It says, any person who shall or shall assist in the writing, printing, uttering, or publishing of any false, scandalous, and malicious writing or writings against the government of the United States, or either House of the Congress of the United States, or the President of the United States, with intent to defame the said government, or the Constitution, or to resist any law, or encourage or abet any hostile designs, etc., upon being convicted in a U.S. court, shall be punished by a fine not exceeding $2,000, and by imprisonment not exceeding 2 years. That's the infamous, and it quickly became infamous, Sedition Act. It had a sunset provision, so it expired just before the Adams administration did. Adams was our second president and our first one-term president, partly because of the Alien and Sedition Acts. And it's gone down in history, the Sedition Act, which incidentally was actually used to prosecute 11 people, 10 of whom were found guilty and sentenced to fines and or jail time. I'll talk a little bit about a couple of those in a minute. But it's gone down as our first great constitutional crisis, the Sedition Act crisis. 1798, fairly early. We haven't had a constitution very long at this point. And the basis that most folks now assume to have been raised to challenge the Sedition Act is the obvious one to us, which is the First Amendment. And if the government did this today, if the government today passed a statute making a crime to say false, malicious, et cetera, things about the government, you got prosecuted, you'd file a First Amendment claim in a federal court, almost certainly, and you'd probably win. This is a violation of your free speech rights to say things about the government, and as we'll see in another lecture, your free speech rights to say bad things about the government are actually among your most protected rights, because we want there to be a conversation about the government. This is how this would be analyzed today. It's not how it was analyzed in 1798. And that's the first point I want to make. In 1798, the Sedition Act wasn't viewed by its opponents as a First Amendment violation. It might have been, but that isn't the argument that they made. And it wasn't viewed as a problem that ought to be resolved by the federal judicial branch. So both of our current assumptions wouldn't have made much sense to contemporaries and certainly didn't represent the course followed by the opponents of the act. Instead, they viewed this as a statute passed that exceeded Congress's delegated power under Article 1, Section 8 of the Constitution. Congress had no power to pass an act criminalizing what people said because it wasn't among the list of things that the state empowered them to do. And the way to resolve it wasn't by going to court, it was by all the states getting together, and this was the phrase used by opponents, interposing themselves between the federal government, which had exceeded its power, and the poor innocent folks who were threatened with being prosecuted under this thing. Now, this was a movement organized by the Adams administration's political opponents, Thomas Jefferson, James Madison, John Breckinridge, and others. And I want to explore the strategy that they opted to pursue, which involved bringing in the state legislatures in a minute or two. But before I do that, I want to say a word on behalf of the Adams administration. We need to, I think it's only fair to view this not only in proper constitutional historical context, but also in proper legal historical context. So what was going on here, and was Adams really as wacky as he appears to us to have been? Was he so completely oblivious to individual rights that he thought he could get away with this? Where was he going, and you know, something wrong with him? Well, the answer is no. Perhaps not surprising. I think Adams actually viewed himself as being something of a progressive on this issue. And to understand that, we need to go back to England for a minute and understand something about the way the crime of sedition was understood by the English. Seditious libel is the full designator for the crime under the Old English law. And in fact, there were a number of prosecutions for seditious libel during the period, during what broadly is our colonial era. But these were prosecutions that the framers would have remembered. The most famous seditious libel prosecution in English legal history, at least from the framers' vantage, was what we call the trial of the 7 bishops, which happened when the Stuart dynasty was still running things. The 7 bishops who were bishops of the established church had protested Crown directive that they read a statement in church on a Sunday declaring that henceforth it was okay to be Catholic, essentially. And they didn't want to do it. The king said, but I'm the head of the church, as the king was by that time. They said, we don't want to do it. And part of the reason that they didn't want to do it was that they were also members of Parliament. They were members of the House of Lords, and they had already signed off on the legislation that said it isn't okay to be Catholic. There were oaths of allegiance to the church and disabilities and this sort of thing. So they saw a conflict between their religious duty and their legislative duty. And the crown took this, the king, as being almost treasonous, this refusal to follow this instruction, and so charged them with seditious libel and prosecuted them. And in the end, the jury let them off, which was a huge victory for jury rights, and part of the reason, incidentally, that I think our ancestors were so keen on juries, because they had been heroic in the trial of the 7 bishops. But the crime was prosecuted nevertheless, and it's an illustration of how seditious libel, I think in the minds of the framers, might be misused. And part of the reason for the misuse, or the element that made it sort of unfair use of power, became clear in the second great seditious libel trial of the colonial era, which was in New York. It was a poor young German guy called John Peter Zenger, who published a newspaper that included some stuff that some political opponents of the governor of New York had given him to publish. He didn't write it, but he published it, and that put him in violation of the English or the New York colonial seditious libel law. And his defense was, it was true, the stuff that he had said, the bad stuff about the governor of New York. And here's where seditious libel becomes weird, because it says false in the English law, but nevertheless, the view in England, as expressed by the prosecutor in the Zenger trial, was that if it was true, that just made it worse. Because if it was true, because the goal of seditious libel prosecutions was to preserve the security of the government, to keep the society from degenerating into chaos. And if you were actually identifying, things that the government was doing that were wrong and pointing them out, then that was going to threaten the security of the state. Well, this is the element that the Adams administration decided to change, and this is the progressive component of the sedition law, one of 2. I'll mention the other in a minute, because they included a provision expressly making truth a defense in a sedition prosecution. So if what you say is true, that's fine. That's absolutely fine. Now, and nobody was able to actually prove that among the folks who were prosecuted. But it was available as a defense, and I think that's something that helped Adams feel comfortable about this. The second thing that I think made him feel progressive was that he put it in a statute. He didn't rely on common law prosecutions, as the English might have done. He said, we're going to lay it out so people can actually read it, see what it says, and then they can make an informed decision whether to comply with the rules or not. They know what the penalties are. And that seemed a rather progressive, enlightened development, I think, to Adams as well. Now, there were prosecutions, I mentioned. I'm going to only say a brief word about 2 of them. My favorite, the James Callender prosecution. Infamous Callender was a notorious publisher who had no qualms. He had boundary issues, I guess you might say. He had no qualms about castigating people publicly. He's prosecuted. The trial is superintended by Justice Samuel Chase, who's riding circuit, sitting as a federal circuit judge. And his behavior in that trial gives rise to a large number of the counts in his impeachment, which was the subject of a different lecture in this series, the impeachment of Samuel Chase. The one that I like the best is the Matthew Lyons prosecution. Matthew Lyons, congressman from Vermont, he was involved in the first fight on the floor of Congress. It involved fire tongs, and he was referred to as I think Federalist Wag called him something like a wild, unmanageable brute, too wild to tame, too base to shoot. which I liked. Lyon gets prosecuted in Vermont, and he calls one witness. He's accused. What he said in an article was that essentially Adams was pompous, that he enjoyed great pomp, and so that was allegedly seditious. And so he called as one witness the judge, who was Justice Patterson, who was riding circuit, and said, "You've been to his house," and that was his entire case. And he went down. I think he was still anyway. But he went to jail. But as did all of these people, and they all tended to be supporters of Thomas Jefferson's. Now Jefferson saw this as a political move, as an attempt by the Adams administration to keep power by silencing the voice of opposition during the campaign more than anything else. And so he used it. They would find cases, they would set people up for prosecution. They'd turn these trials into shows, which is sort of what Matthew Lyon had done. And then they started this attack, this constitutional attack. And that's the last thing I want to visit about before we finish. The constitutional attack wasn't a lawsuit saying that the Sedition Act violated the First Amendment. Instead, what Jefferson decided to do with Madison was to use the states. Now, Madison had said in one of the Federalist Papers, what happens if the federal government goes crazy and starts exceeding its power? And he said, well, the answer is, and it wasn't the Supreme Court will rescue us, it was the states will rescue us. And understand that the states had one really effective way of doing this. The states the legislatures elected the members of the U.S. Senate. So if the states got together, recalled or ordered their senators, which the states would do, they would direct them to vote certain ways because they represented the legislature, then the states actually could change federal policy directly. Or they could replace people who refused to comply with legislative directives. And it may be that that's what Madison had in mind. But Madison and Jefferson and John Breckinridge in Kentucky produced and introduced into the Kentucky and Virginia legislatures resolutions expressing the view from the legislatures that the Sedition Act was unconstitutional because it exceeded Congress's delegated powers, and urging the other states to get together to fix this problem, that the states as states would solve this problem. They used some unfortunate language, it turns out. They used interposition, and they used the word null, and that turned out to be the unfortunate legacy of the resistance to the Alien and Sedition Acts. Let me finish the politics, and then we'll finish the Constitution. The politics, the act expired before Adams left office. He wasn't reelected. Jefferson was, with Aaron Burr, his vice president, another story. And Jefferson allowed the Sedition Act to expire. There was subsequently an attempt at a common law seditious libel prosecution in 1812, but the Supreme Court at that point said there is no federal criminal common law. And we've never had the Sedition Act, at least in that form, since then. So politically, it sort of disappeared without a need for a judicial resolution on the First Amendment issue. But the other legacy is this constitutional legacy, and it's a constitutional interpretation legacy. It's not First Amendment related. It's related to who are the parties to the Constitution and what rights do those parties have. Because Jefferson, as I mentioned, and Madison and Breckinridge had introduced into the conversation this word null, that acts of the legislature passed in excess, the national legislature passed in excess of its power could be considered null within the bounds of a state. And that gave rise to the doctrine that came to be known as nullification, which South Carolina would then seize upon and expand in the 1830s in claiming that it had the right to refuse to follow or to collect or allow the collection of the federal tariff on imported goods, giving rise to the nullification crisis of 1832, and then less than 30 years later, giving rise to South Carolina's secession from the Union on the grounds that the federal government had failed to abide by the deal that the states had put together in the Constitutional Convention. So our first great constitutional crisis turns out to come and go politically, but the reaction to that first great constitutional crisis will unintentionally give rise to a much greater constitutional crisis in just a few years' time. Thank you.
Freedom 101 is made possible by generous support from the University of Oklahoma Alumni Association. Freedom 101 is a program of the Institute for the American Constitutional Heritage at the University of Oklahoma. For more videos and podcasts, visit freedom.ou.edu.